we're really wanting to talk about today is the role of the family dispute resolution practitioner. It is a part 2. Before I go any further, I'd like to acknowledge the Aboriginal and Torres Strait Islander people as the traditional custodians of Australia and recognise their continued connection with the lands, waters and culture. I pay respect to elders past, present and emerging leaders. And I come to you today from the lands of the Gunai people in Gippsland in Victoria. Now, if you'd like to use the chat to introduce yourselves, we're actually quite a small group today, but make use, and really it would be great if you do feel like contributing and any questions or comments as we go through. We do have, it will be recorded and put up as a recording, so just be mindful of that if we're talking about cases. So I'm going to skip through the first part of this presentation because we did do it on a different session, and that's available on YouTube, so you'll be able to have a look at that if you are interested. But really looking at the role of the FDR practitioner and where I guess, the specialist skills that we are required to have. So sometimes there's some confusion around whether people can do family dispute resolution just with a national accreditation, and I'd really encourage people to realise how much additional skills and knowledge that we need to have and bring together into the work as an FDR practitioner. It's more than just not being able to issue a Section 60I. So the first part of this recording presentation is on YouTube, and on the notes of this presentation, I have got it available in PDF format. It's got the link, or you can just go to the Mediation Institute YouTube channel. So I'm going to just go through the various parts that I have already done, but really what I'm looking at is the core units from the graduate diploma and the skills and knowledge that we need to have based on that. And the first part that I talked about was, or really looked at, was that family violence context and the knowledge that you need to have. The other part of that knowledge is support the safety of family members who are subjected to violence. It's not enough just to screen for violence. We need to think about, do we need to actually take action? Do we need to do something to make, as much as we're able to, this family safer? So part of it can be making information available about the prevalence and impact of family violence, because sometimes people really don't appear to be aware that their behaviour is family violence. They don't really seem to understand that their controlling behaviour, limiting the choices of their partner is in a way that really isn't acceptable under Australian family law, basically. So sometimes there's an education component. They may come to us with family violence orders that they think are completely unjust, but then when we have a conversation about what's happened, we might need to provide them a little bit more context of why that order's actually been approved. And we need to be very clear for people about the harms that exposure to family violence is known to cause children. Often people have come from a family home where they were exposed to family violence, maybe at a much more extreme level than their children have been, but that doesn't mean that it's okay. We still need to work with them to help them understand that maybe some of the impacts that they're experiencing are going to be perpetuated without a break in the cycle. We may need to think about safety plans. We know that separation and divorce is a time of heightened risk for family violence. We know it's a time where there's the potential of breakout violence, changing of the pattern that's been there in the past. And sometimes it's necessary for people to really think about their situation because they may not really have considered the risk. So the most usual, and some might say appropriate way, is to refer clients to a specialist service who can support them, but there may be situations where that's just not possible, either because they're in a regional or remote area where the services are very few and far between and overwhelmed, and so the waiting period might be too long, or it may be that there's really urgent, imminent risk. So there might have been something that's happened in the mediation one of the persons stormed out, disconnected or whatever, and there's a concern that they may be intending to follow through on a threat, or they may be a threat in their current state of mind. One of the expectations is that we build networks with relevant service providers and establish that, have the knowledge that we need to establish an environment that supports appropriate disclosure. I was talking to a student very recently, and he was saying that in a role play, his role player, who was also and who was a brand new student, was saying, "Oh, why do we need to ask all these questions in a property mediation? It's just property. This is intrusive. It's not relevant to ask them about family violence or drugs or things like that." But it definitely is. So we know that the obligations that we have as family dispute resolution practitioners is to ensure that the process is fair and that people are able to make informed decisions free of coercion. So if there is family violence, if there's financial abuse or other forms of abuse being used to try and coerce someone into an agreement, we're not, it's not our role to be the tool for that. If that makes sense. So look, if anyone's got any thoughts about this, feel free to use the chat or to come in to the conversation. Again, we have an obligation to align service interventions to specific clients. And that really, we're talking about things like using shuttle where it's necessary based on our analysis of the situation. Sometimes gender. So sometimes because of people's cultural background, gender is going to be very important to them. And we have an obligation to be mindful and sensitive to that. So it may be that it's necessary to use a co-mediation model where there's a gender balance, if that's something that's very significant to the people. And really, I suppose, continually checking in. Some people say, "Oh, I don't bother with private sessions. That's a waste of time." I'd argue the opposite, that I think it's very important to make sure that people are not being swept along because they're frightened to raise their objections in a joint session with someone that has used family violence against them in the past or may have made threats or something. If it was assessed as being appropriate to proceed to mediation, doesn't always mean that it's appropriate to continue. Yeah. And when you know if there's family violence, then yes, Bonnie, that's absolutely right. A check-in afterwards can be very, very helpful as well. The other thing is, if we know there's a history of violence, perhaps there's been mandatory reports in the past, but if the parents have agreed to a change in parenting arrangements that are going to change the risk profile, then perhaps that's an opportunity where you might need to contact the child protection agency that's relevant for that child and just have a conversation about things have changed, and just to alert them that we don't have the information that they have, they don't have the information that we have. So sometimes it's advisable to make that call and bring them up to date. So mandatory reports, remember, mandatory reports relate specifically to concerns around child protection, risks of harm, neglect, other issues related specifically to children. So we should be documenting that, keeping a file note if you are making a mandatory report, who, when, why did you make that report. There is a very limited, small chance that you could be asked to provide more information to a court in those matters. I believe it very rarely happens, but it is an option. If we issue a Section 60I certificate, we again, they can be issued up to 12 months after the last mediation or attempted mediation. So we need to keep records around that. The same if we do a certificate of dispute resolution. And if there were any safety concerns where you've had to take action to maybe refer people to family violence or contact the police or anything like that, all of those sorts of things should be documented on your client case. Sometimes there's, yes, and certainly if there's been an agreement reached, you'll be wanting to keep a record of that. Sometimes it's outside our control whether we have a copy of a parenting plan. We may just have the parenting agreement and it hasn't been signed, or the signed copy hasn't been returned to us. So we only got a parenting agreement on file. We don't have any certainty of whether or not they've signed that agreement. Okay, so that moves on to the skills. So that's the key points around safety, of making sure that we are properly assessing risk, that we're bringing in the specialist or referring people to the specialist where we can, but we all have the skills to be able to work through with the clients directly where we need to. And if that's something that you're thinking, oh, I'm not really sure that's I'm comfortable with that might be an area for you to focus on with your professional development. The next element is the actual practitioner skills. So the FDR practitioner skills, which are outlined in the unit about operating as a family dispute resolution practitioner. So again, screening is really highlighted as an important aspect of the process. So obtaining and analysing existing client information. So sometimes FDRPs will say, oh, I don't take in any information at all. But if we really need to, if there's family violence orders, we need to collect that information. If there's an existing parenting order or an existing parenting plan, we need to have a look at that and understand what's working and what's not working. We may need to collaborate with colleagues and professional networks. Certainly, it may be that you'll need to talk to the referring lawyer or agency if there's issues around expectations, particularly if there's a family violence order that's relevant to the situation. So really looking at making sure that we understand what the issues are, and then compare them with our obligations under the regulations to make sure that people are freely able to make decisions in FDR. And using the intake process to receive and share information that supports positive outcomes for potential participants. So the intake process isn't just risk screening, it's also helping people to consider their positions, trying to help them to identify their underlying interests, helping them to think about being flexible in their thinking, so think about different options for them to achieve their interests. So all of that sort of conversation should be happening during that pre-mediation to help people prepared. And then identifying situations beyond the scope of our own practice, so making relevant referrals. So that would relate to referrals for legal advice, it might be financial advice, it might be for counsel, it could be for drug and alcohol, it could be for it could be a housing support service, all sorts of different reasons that people may need to get additional support before they start family dispute resolution. It could be to a service, the one that Jeannie Magri runs, Parenting Together Apart, who do a more intensive coaching style program. It may be bringing in divorce or separation or conflict coaches. Could be sending them off with information about various courses and other things in that way. And please feel free to share if there's other sorts of things that you do with clients to help them to prepare to be ready. We've got where I do my mediations at Interact Online, we've got a parenting plan, a really very comprehensive template for a lot of different things that they might need to consider if they are wanting a full parenting plan that they can work through beforehand. And of course, information about the new definition of best interest of the child and other changes that have come through the system recently. That's an area of change that parents that have been in the system for a while may not be aware, or parents coming into the system for the first time may not be aware of. And then preparing for the dispute resolution process itself. So analysing, preparing information to support the process, explaining the process to the parents, participants, and advising them of your role, obligations and limitations. So all of these are expectations. So people should have very full informed consent about the FDR process. Limitations on confidentiality. So where you may breach confidentiality, which is usually around if there's a need for a mandatory report, if there's risks of harm to a person or self-harm that you may need to take steps in supervision or within your organisation, depending on how you're structured, and any other exceptions. Oh, and Bonnie's shared in the chat that she sends out a flyer that helps them define their own needs and fears and gives some ideas about agenda topics. Yeah, because sometimes people just don't know what they should bring up or could bring up. So helping people to understand that particularly if it's a parenting mediation, that we're going to be asking them about the issues they'd like to bring to mediation to try and resolve, and that they're going to have an opportunity to speak about those things. So if people aren't prepared, often they'll feel uncomfortable, unwilling, unsure about bringing things up. Excellent. Any other thoughts or any questions about that preparation phase in the dispute resolution? So again, assisting the participants to define and clarify the issues. And this is where we're using our interpersonal skills, organisational resources to identify issues for consideration. And that's very much what you're talking about, Bonnie, I think. Screening, again, going back to screening, it's a core skill that we need to assess, evaluate and act upon risks that are present. I've done specific presentations on risk screening, and it's never about there's a 100% guaranteed absence of any risks. There's always some element of risk, but we need to be really considering and continuing to monitor that. We need to provide a process where people can feel like it's safe for them, emotionally, psychologically safe for them to articulate their concerns, to be able to negotiate and develop an agenda. Again, thank you, Bonnie. Great. You can walk and talk. Feel free to turn on your mic if you want. But yeah, BATNA, the best alternative to a negotiated agreement, and WATNA, the worst alternative to a negotiated agreement. Talking that through with them and helping them the clients to identify that can be a really good way of helping them to see if they actually have enough information, if they're prepared enough for mediation, and also whether their concerns, their beliefs around what their alternatives are realistic, or whether they're either overly optimistic or catastrophizing. Usually, if we can help people to have a realistic view, they're going to be in a better frame of mind to make the most of the mediation opportunity, but less likely to be pushed into agreeing to things that aren't in the best interest of their children if they've got that catastrophizing mindset of what's on the other side. And that often can help people to speak up a little bit more and allows us in the mediation to get to much better agreements with better contingency planning and better reality testing. Yes, prepared clients are the very best of clients. Now, I've put a note in there about not disposing of all information following FDR. There's a little bit of a urban myth sort of thing that goes around about, oh, mediation's great because you can just throw everything out. That is really not good practice. You need to have the information to be able to issue a Section 60I within 12 months. All of those, I think I preempted this because it is so important. But it's really important that you also, if you do dispose of information, that you are very mindful that it can't be flying around in a landfill or pulled out of your bin. And and again, we want clients to come back when their needs change, when their family situation changes, when there's a difficult decision that they're not able to manage. That's not a failure of mediation. That's providing mediation as a way to help conflict escalating in families. And it's very helpful that we have the history of what's occurred. It doesn't mean that we just pick up from where, if it's been 3 or 4 years, we're still going to have to evaluate what the current situation. But if we remember who the clients are, their children, we've got the details of the agreement they reached, is going to be a much better experience for those clients. Yes, so we definitely don't just throw everything out, but we do have an obligation to make sure the information is securely stored. We all know that giant corporations get hacked and things like that. Electronically storing information is very helpful, but at least do what you can, two-factor authentication and appropriate protocols around the storing of information. And again, so some of the skills, so facilitating communication and information exchange. So that's one of the critical things that we have. So encouraging active listening between participants. And that's a lot more than just say, can you respond to Jack? Can you respond to Joan? There I get those names, but obviously an older couple. It's really refining our skills so that we can identify where the key elements of what's been said are, and if necessary, help the clients to develop their skills to respond to what they're hearing. We need to make sure the process is fair and respectful. FDR isn't a place where people should be venting their emotions and creating what feels like an unsafe space. Ensuring the participants have an equal opportunity to speak, that can be really difficult, because sometimes you can have someone who's a big speaker, likes to talk a lot, and someone who doesn't speak very much. Sometimes people can deliberately try to overspeak and use up the time. So we need to have our skills at respectfully interrupting, managing that flow of information, slowing people down if they're wanting to put 10 issues in the one breath. Really, one of the skills that we have is packaging and managing information, not in an overt way, but in a facilitative way, so that we're assisting clients to manage so that they're actually being heard. Presenting needs, interests and concerns. So if we've talked in those terms in the pre-mediation, it's going to be a lot easier for clients to talk about those things rather than just trying to have a positional negotiation over percentages. That's going to be the probably least successful type of mediation if all it is just bargaining, that positional bargaining style approach. We also need to not be steamrolling people into an agreement. That would be, really unethical. So part of the obligation is to provide sufficient opportunity for participants to have access to advice and information if they need it. Again, private sessions, identifying the need so that clients can have that opportunity to speak privately with you. And sometimes you hear people say, I want to keep them there until they've got an agreement. I guess the question is, if you get an agreement in that way, is it really going to be sustainable, or is it likely that it's going to fall apart before it's even signed off? So unless people are really congruently willing to participate in reach that agreement, unless you've really reality tested to help them think about the options, it's not really what we're expecting from a family dispute resolution practitioner. So we're really wanting to frame the disputes to increase the range of options. So that's why when we create an agenda, we chunk up, we make sure that it's not a narrow focused in on what the solution is to the problem. We're wanting to frame so that people can have a number of different ways of resolving an issue. It's schooling, not whether they go to this particular school or not. And so that in itself, creating an agenda that is still useful but increases the range of options, is another skill. This is a skill of any mediator, but particularly when we're talking about family law mediation, we need to really support that option generation and client self-determination. Now, it's the biggest difference, I think, for family dispute resolution is we've got that added element of really part of our role isn't neutral in the slightest, because we're really bringing people back to think about the impact on their children and how the decisions that they're making are going to impact the children. So it's not that we necessarily have a specific narrow view of that, but those important factors around safety, the child's developmental needs, their relationship with other family members or other people, their cultural needs, all of those are factors that we may proactively bring up rather than just waiting for the parents to bring up. So if they don't, we have the issue that we need to make sure that they are considered. And then when we're getting into that exploration phase, we're really thinking about, or right through, but encouraging that mutual personal understanding between the participants. And where possible, so acknowledgements of needs, fears and concerns of the parties. So if we can get people to share those concerns, it's going to lead to a much more appropriate mediation than if people are just stating what they want. Again, some of the things that people need to express are quite emotional, and so we've got to help facilitate that balance between people who might become upset, but also people who may use emotions inappropriately. So it's a very fine line to know whether someone's doing that deliberately or just because their ability to control their emotions at this point in time is just not up to the situation they're in. And we need to, again, continue to assess those risks and either terminate and suspend the process, go into private sessions. If it's not appropriate to continue at that point, we've still got obligations. So if you're in a service, hopefully they'll have a protocol and a process that you can follow through. If you're not, if you're in a private practice, then you need to think through what's going to happen if a client's desperately upset at the end of partway through a mediation. You've got to pull the pin. How are you going to make sure that their welfare is managed, particularly if they've expressed in your risk screening that they might have some concerns around past thoughts about suicide or whatever issues that might be there. So we can't really just, okay, that's over, that was pretty bad. What are we going to, is there an obligation to do something to try and help with that situation? Hopefully that doesn't happen very often. Usually that's able to be managed, maybe with a breakout or a little bit of time out, a conversation to help people to consider their options, reframe perhaps. But then considering and generating options. So again, we need to have the skills and the strategies to be able to help people to come up with options. We're not really doing much in FDR if all we're doing is facilitating a discussion of people's various positions and trying to shift people. So we want to shift that conversation away from positions to interests, so what really matters, and then looking at ways for those what really matters things to be met for everyone involved, particularly for the children. But if parents needs at least some level are not going to be met, then the agreement's not likely to persist very long. And then again, sometimes you've got people who have completely unrealistic expectations, or they might be very much longer term to achieve that. And I'm thinking of the classic situation where a parent hasn't seen children very much, but they want 50-50. It's there where we're helping participants to think about options to improve the situation from where they are. So it's unlikely they're going to just jump from 0 to 50% of the time. If that's ever going to be appropriate, it's probably not going to be an appropriate thing for the children just to be dumped straight into that situation. So bringing it back to the children, how's that going to be for them? What are ways to make sure that's an appropriate pathway? And of course, the other parent will be giving you input into risks and concerns. So any thoughts about these skills and techniques that we need to use to achieve this? And we can certainly look into those in a lot more detail. Now, documenting agreements, this is a really important part as well. Yeah, the best interest discussions can be quite challenging, particularly. I think the new best interest factors are helpful. I think the simplification has certainly assisted, but I'm finding getting information out to parents beforehand. I've done a little video that I send out to people about them. But yeah, it can be quite challenging to get people away from their stuck view of what's going to be best for the child as opposed to best interests of the child according to the family law system. It's not always the same in people's minds. So we need to, in family dispute resolution, in general mediation, we talk about the agreement being documented in the participants' words and however, whatever works for them. In FDR, we're working within a context, so we need to understand and we need to talk through with the clients what is the context of their agreement that they're planning to reach. So if they've had they're just separating, there's still a lot of anxiety and angst around that, then they're probably going to need a parenting plan. Often things aren't really settled, so they're going to, by the very nature of their situation, it's an interim process. The longer term decisions, getting a full parenting plan that would be suitable to turn into orders, it may need some more time for that to be ready. So we need to be able to talk to people about that. If they if they're getting orders, particularly if it's property, we need to make sure that we're collecting as much of the necessary information as we can so that when they go to their lawyers to get the agreement written up, or rather the orders written up, or if they plan to do one of the do-it-yourself processes, then all of the required information, the regos, the bank details, the details of the superannuation, all of that's available to streamline the process. And of course, we need to make sure that if participants are reaching an agreement, that they are signing it freely, voluntarily, without undue influence, and on the basis of informed consent. We know that in the case of parenting, if they sign an agreement about parenting, it's got the ability to modify terms of an existing parenting order unless the order specifically says that it can't, and it has to be considered by the court, but it's not a enforceable contract, so to speak. It's something that has recognition. It's definitely evidence of agreement at that point of time. Parents need to know that. We can't write something up and say, oh, sign it if you want. It doesn't really mean anything, because it does. It has legal significance. And then with property, we need to let people know that if they sign and date it, it's not a legally enforceable document. They'd need to get a binding financial agreement, which means legal advice and signing off to say that there was independent legal advice. If for whatever reason consent orders aren't appropriate, or they'd need to apply for consent orders. Again, if they sign it, it could be used as evidence, but it has no legal weight at all. And if someone wants to claim that they were coerced or whatever, it may be disregarded as completely, certainly, and particularly if a fair bit of time passes before whatever they've agreed to is planned to be implemented. So it's really important that we document very clearly, about what the assets are, what the situation with the children are, who's going to do what and when. The general rule of thumb is the higher the conflict, the more detail you need. Sometimes where one person has got more power than the other in the relationship, that person wants the agreement, everything to be by agreement. So from their point of view, they'll continue to dictate what can happen. I'm sure people have seen that. Yeah. So any thoughts on agreement writing? Is that an area that's pretty easy or more challenging to know what's in there? Feel free, if that's something that you'd like us to do a specific session on with examples of the sorts of clauses and things that you might see, maybe that's something we could schedule as well. So no. Yep, no problems. Cassandra, we can definitely look at scheduling something like that in and looking at some bad examples and hopefully some good examples. We might maybe we can get one of the lawyers that that are on the other end of getting agreements from mediators to be part of that. I'm always looking for ideas for us to look at. With the graduate diploma, it overlays our basic obligations, our ethical obligations, and again, obligations around family violence. Yeah, excellent. So we'll definitely schedule that in. Determining ethical responsibilities. Our main obligations are outlined in the FDR or Family Law, Family Dispute Resolution Practitioners Regulations 2008. They are sunsetting and there'll be a new version out on or before the 1st of April 2025. So the Attorney General's Department's working on that, whether there's going to be any changes that come through, but generally our obligations are around safety, avoidance of conflicts of interest, and the similar sort of ethical obligations that we have as in any form of mediation. It identifies as well ethical. So some of the things are informing participants about their rights and obligations. So having people in FDR without having provided that information, and my encouragement would be always provide it in writing and get them to sign off to say that you've provided that information. And I've got my complaint handling hat on there. It's very hard if you do end up with a complaint for you to say, oh, yes, I said all of that, because if you're saying you've said it, they're saying you didn't, and you haven't provided it in writing as well in a format that, in a way that we know that it was actually provided to clients. You really haven't met your obligations. Provide information to participants that supports ethical practice, making sure that if there is a conflict of interest or a potential conflict of interest, rather, if there was a real conflict of interest, you wouldn't proceed. If there was a potential conflict of interest, such as a previous relationship in another context, and everyone's decided that it's appropriate to proceed, then documenting that, getting a written confirmation that everyone has agreed to proceed is again strongly recommended. The typo there, and isn't a special technical term, it should be and take responsibility to avoid potential dilemmas or conflict of interest. We basically need to be looking for issues, identify them as soon as possible, discuss them as appropriate, and if they're not able to be resolved, we need to stop the process, refer to someone else. We can't ethically facilitate a process where we do have a acknowledged bias or a really inappropriate relationship. So if clients are identifying or raising an issue, we must very seriously respond to that. And usually it's around, if you're also a lawyer, and it may be a conflict of interest around previous work that's been done with parties, counsellors, if you were doing individual counselling with someone and then they want to do family dispute resolution, that would generally really be a conflict of interest. You should be referring that out. Feel free to use the chat for other sort of examples that you're thinking or you might have come across in terms of ethical dilemmas. And the other really important thing is to make sure we're reflecting on ethical practice. We know as humans, we all have biases. We have certain perspectives on life. As FDR practitioners, we try to avoid those affecting our behaviour, but we need to be constantly considering how, even if there's not something overt as a previous relationship or whatever, we need to be thinking about, do I really dislike this person? Like, I really dislike them. I don't want to work with them. How will that affect your facilitation? You may need to think about the ethics of continuing in that. You're probably not going to use, I really dislike them as an excuse, but it may be appropriate for you to refer. Evaluating your own responses, participating in supervision, ongoing reflective practice, working with colleagues. We should all have a group of other colleagues that we can contact and talk through, participating in group supervision. All of those sorts of things are critical to FDRs. practitioners. So I won't put you on the spot by asking who's not doing any of this, but I'd certainly like anyone to share the sorts of things that you are doing to reflect on the ethics of your practice. Are you consistently doing the right thing in terms of obligations to clients? So the other elements, and I'm going to go really quickly through these. Again, support the safety of vulnerable parties. So it's really layered on about family violence, safety, using appropriate risk screening protocols. So we shouldn't be just turning up with a blank paper and just saying, oh, is there any issues? No, okay, that's all good. It's really an obligation and expectation that you'll have a structured process around that. That's the orange door. If you're in Victoria, that would make sense. If you're in another state, who are the family violence support services? Who can you refer clients to if there's situations that threaten their safety? And child-focused practice. So again, and we had a little bit of chat in there about how difficult it is to get parents to reflect on best interest of the child. So it may be referring them to post-separation parenting groups, courses, individual work. So there's various resources around out there, and also whether we can do child inclusive practice. So again, finding out where the practitioners are, how they work, making sure that we can help parents to understand those options and how we can respond to that child inclusive work. If Attorney General's Department fact sheets, they've got some on family violence. They've got the ones there. Yeah, look, there's a question about providing child inclusive practice as well as FDR. There are a couple of models of that around. I'm not sure I'm a huge fan of it. I think having that, there's pros and cons, and that could be a good thing as well. Get people that are doing various different forms of practice to talk about the pros and cons. Yeah, for me, I see a huge benefit of someone spending time with the children and then coming in to the mediation with the parents. Sometimes the debrief with the parent, again, there's another area of contention. Should the debrief happen directly with the parents and then they're expected to mediate, or is that too much pressure and they should be having a debrief with the child consultant first and then coming to mediation at a later time? So yeah, we've been trying to get a child inclusive session up, but we might maybe we'll get some people with some different perspectives on that to make it even more interesting, but that will definitely be coming. So just the conclusion, it's really high level professional skills that we need as FDR practitioners. Safety is really woven through where we don't have the resources of the court. So we need to make sure that we're accessing all of the resources that we have available to try and keep families safe. Like we all know about the absolutely horrendous statistics of parents murdering their children, murdering their former partner. And yeah, we're part of the system that needs to stop that and try and keep people safe. And and this is for our other events, just Mediation Institute website /events. We've got an early one. So 8 a.m. we're testing out that time slot, and that was when Juvie was available. And next week I've got presenting along with on this time on family property matters. So actually she is a family lawyer, so we can talk a little bit about the agreements. And yes, we're going to have a little bit of a demo and exploration of Magenta and what's happening there with an alternative tool for helping with property settlements. That's on the 2nd of July. So yeah, so thank you everyone. I'm going to stop at the moment because we've run a little bit over, but we started a little bit late. And yes, we will be recording Cassandra, yes, and putting those, it was Cassandra. Yeah, we will be putting those up. We're putting most of the recordings up on YouTube these days, and we'll be launching our new membership platform soon, which will have the links to be able to be found